You skew the playing field in favor of the licensee over the licensor. You skew the playing field to benefit some of the largest companies in the world who have not, for the most part, contributed to the development of the technologies that enable devices like the smartphone. And that's why you get this situation that seems quite paradoxical. How could it be that some of the largest tech companies in the world don't like patents? Well, they don't like patents because in many cases, they are a net user of technology. They're an integrator, they're an aggregator. They're not the originator of that technology.
Hello, I'm Bruce Berman, the host of Understanding IP Matters, the critically acclaimed podcast series that provides leading innovators and experts a space to share their IP story. Learn firsthand about the strengths and weaknesses of copyrights, patents, trademarks, and trade secrets as they adapt to an AI-driven world. This is our 4th season. Jonathan Barnett is author of an important new book, The Big Steal: Ideology, Interest, and the Undoing of Intellectual Property. The book examines the weaknesses of the U.S. IP system, how they occurred, who they benefit, and what can be done to repair the damage. It also explains how these failings impact innovation, commerce, and democracy. Director of the USC Gould School of Law Media, Entertainment, and Technology program, Jonathan specializes in antitrust, intellectual property, and business law with a focus on innovation policy and strategy. Despite Jonathan's formidable academic credentials, The Big Steal is easily read and understood by creators, entrepreneurs, and consumers, as well as investors. Prior to academia, Jonathan practiced corporate law at Cleary Gottlieb in New York, specializing in private equity and mergers and acquisitions. He is a graduate of the University of Pennsylvania, Cambridge University, and Yale Law School. Welcome, Jonathan. Where are you speaking from today?
I'm back in New York City.
You're from New York, are you not?
I worked in New York, grew up on the East Coast, so kind of coming back home here. Yeah, most of the time I'm out in the sun in LA.
Your recent book, The Big Steal, about the undoing of intellectual property, as you put it, is an incisive analysis of the current U.S. IP system. It makes a strong argument for restoring IP rights to the approach the U.S. once championed. Did anything about the response to the book surprise you?
I've gotten positive responses from portions of industry, portions of the policymaking community that understand the practical necessity, urgency of preserving IP rights, some form of exclusivity in both the tech and the content markets. I have encountered less interest from much of the academic community, which I think reflects, as I discuss in the book, the consensus skepticism in much of the legal academic portions of the economics community toward the necessity of intellectual property rights in innovation markets.
The book is surprisingly accessible to non-IP and non-legal people. Was that part of your goal in writing it?
Sure, absolutely. I published a book back in 2001 called Innovators, Firms, and Markets, and that was more of a book focused for the academic audience that pulled together economic history, economic theory, economic evidence to explain the importance of intellectual property rights in supporting innovation and commercializing innovations. What I've done in this book is to adopt a style that makes it exactly as you said. It's accessible to industry, it's accessible to policymakers, it's accessible to academics, it's accessible to anyone with an interest in understanding the role that IP rights as a practical matter in taking an innovation, taking an idea, and converting it into a product or service that consumers can actually enjoy. This book was designed to take about 15 years of academic research, crystallize that, boil that down into a form that can really make an impact on something that I think is of vital importance as a policymaker for the U.S. innovation ecosystem, and I would even say globally.
It's not what you're saying is so earth-shatteringly new, but it's how you say it. You're able to really articulate clearly the dynamics of IP today, where it is, how it's evolved, and why it's less than perfect. A lot of people don't get that.
Yeah, that's exactly the point here. You put that nicely. This book is really about taking IP policy and bringing it back to common sense, right? So if you anyone who's out there in a real world physical goods market like real estate, there isn't manufacturing. There isn't any room for debate that you need to have secure property rights to elicit investment, create jobs, create new products. And really, if you want to boil this book down to the absolute kernel of the book, it's just that the same logic applies in intangible goods markets, in tech and content. These things take money to produce. They require people to be paid and paid fairly. All of that at the end of the day, you need to have some form of property rights, some form of exclusivity so that creators, innovators, all of the entities that assist the creators and innovators, and there are many of them, that they are all paid an amount that reflects their contribution to the ecosystem. That's really what this book is about.
Jonathan, the IP playing field, has never exactly been level for small businesses, independent inventors, content creators. On balance, though, it's been workable for those who persist. The IP system is considerably less viable for them today. Almost impossible today are businesses founded in garages like Apple and HP, and on kitchen tables, in dorm rooms like Google and Facebook. Why is achieving IP success so much more difficult today?
The reason that it's difficult for the individual inventor or the small firm inventor or anything that I put into the category of the idea factory, right? You can go back to Thomas Edison in Menlo Park, New Jersey. You can go to the HP example in the garage in Silicon Valley. For each of these types of inventors, and there's a long list of examples in US tech history to illustrate this. IP rights level the playing field. Okay, and let's boil this down. Why is that the case? It's the case because if you're an individual inventor, if you're a small firm inventor, your asset is the idea, right? But to take that asset, that idea, and convert it into a product or service that consumers can use, a lot of other things have to happen. A lot of other things that are very expensive and they're often very labor intensive. And for that whole rest of the pipeline, moving from idea to product, that's where the larger firm has an advantage. They already have that infrastructure in place. They already have that capital available. What the IP right does, it just enables that playing field to be leveled in a way that gives that small firm inventor a chance. If you just cut through all of the economics, if you go back to the history of the US patent system, and the same is actually true on the copyright side, the theme of the individual inventor, the historical importance of the individual inventor, it's a driving motif, a driving theme behind the system. It not only makes sense in terms of history, it not only makes sense in terms of values, American values, it also makes sense in terms of the economic considerations that I just mentioned. And it's not only good for the individual inventor, or what I like to call the maverick inventor, the inventor that challenges the existing design, the existing paradigm. It's good over the long term for the whole ecosystem. It enables that creative destruction cycle that we like to see, and it makes the US tech ecosystem especially robust.
The DNA of innovation is improved by having a variety of challengers to invention. So there better inventions are created. Obviously, patents are not a monopoly right. They provide exclusivity for a period, limited exclusivity. But I call patents the anti-monopoly monopoly. They level the playing field and they allow leverage for those who don't have it. Without that, there's 3 or 4 or 5 companies determine what's innovative and what's not, and that's not that healthy. Jonathan, extremely wise people don't understand the use and impact of IP rights. Most think of them as costly impediments, not potential assets that encourage investment and sharing and that facilitate healthy competition, as we were just speaking, and innovation quality. What do you think that is?
Yeah, I talk about in the book kind of two communities that are deeply skeptical of IP rights. And I don't dismiss the skepticism. I treat it with the utmost seriousness and attempt to explain why it's misguided. But to understand that, let's understand why these two communities One, the legal academic and some of the economics departments in the country. And on the other side are platform-based tech companies. So not all of the tech industry, but the platform-based tech companies, right? On the academic side, I think it's a combination either, in some cases, of ideological skepticism toward property rights, towards markets. Okay? But even when it's not ideological, I think it's a reflection, especially in the economics disciplines, of using a model that simplifies IP rights, simplifies innovation ecosystems in two ways that kind of moves you away from reality. The first one is to assume that IP rights are always a monopoly. In fact, the evidence tells us that they're almost always not a monopoly. There's simply something like a property right over your home. So do you have a monopoly over home? Yes, you do. Do you have pricing power in the real estate market? No, you don't. And that's pretty much most of the time the way an IP right works. The other simplification that we see in the economics models is that they move from innovation to product instantaneously. And so what they miss is all of what I'd mentioned earlier, all of the costs and the labor intensity and all of the logistics that's required to convert that idea into a product. And so with those two simplifications, you can reach what I show in the book or argue in the book are misguided views of the functions of IP rights in real world markets. Okay, so now let's move over to that real world where we have platform-based firms that are skeptical of IP rights, and as I show in the book, they invest extensively in lobbying and advocacy activities successfully to reduce the force of those rights. Okay, and there's nothing about this that is nefarious. It just derives from their business model.
So the myth of the patent troll as a threat to innovation, that's somewhat orchestrated, you think, by those who benefit from that perpetuation of that idea?
Well, I describe in the book a series of what I call patent horribles. The patent horribles are things like patent thickets and patent trolls and patent holdup and junk patents, right? And so what do they have in common? Well, they have in common that they usually have kind of a catchy slogan. And they also have in common that they're often grounded in a preliminary empirical result or a theoretical conjecture. And that then snowballs through advocacy or lobbying activity into a generalization that is exaggerated, often significantly beyond the empirical basis, or often simply ignores later empirical studies that show that the original finding was either overstated or, in fact, was incorrect. What's driving this is a business model where either content assets or certain tech assets are an input. Okay. In any business out there, whether you're in the building business, the cement business, whether you have an ice cream store, okay, you want to reduce your input costs, right? The way you normally do that is within the rules of the game, you bargain with your supplier to get those costs down. Okay. One of the key insights, if not the main insight of this book, is that the largest platform companies have invested resources into changing the rules of the game within which IP assets are bargained over. And it's the most fundamental rules of the game that you could imagine. It's the property rights structure of the digital economy. Okay? Through litigation, through advocacy, through lobbying, they have changed the rules of the game in such a way that it's an across the board reset downward of the value of all IP assets and content and tech markets. It's hard to overstate how huge the shift has been. And it's also incredibly interesting that it's largely been underappreciated what has occurred here. So just to illustrate this, if it's not clear, if you're a platform like YouTube, right, users are uploading content. You want as much content as possible up there. You want the highest value content up there. Now, how could you achieve that? You could achieve that by reducing the price of that content as low as possible. And the number you want to get to is zero. Okay, so you pay nothing for that content. Now, how could you possibly do that? Well, the way you could do that is to litigate and to secure legal precedents that exempt the activity of users uploading that content, the activity of the platform hosting and distributing that content. You exempt that from legal liability. You have just procured a massive inventory of content at a price of exactly zero, and you have just maximized the profit margins, the profits for your shareholders, as you're legally obligated to do as a YouTube manager. So that's the business logic, trying to get that content input cost down to the game.
You make numerous observations in your book that capture the diminished status of IP rights really well. Here's one I will read from the book. A critical factor that stands behind the success of modern IP skeptics is what I call accidental alliance, composed of well-resourced business constituency that shares interest in weakening IP rights with academics and advocacy groups that have ideological or other intellectual commitments to a strong presumption against robust forms, or in some cases, any form of IP protection. Can you expand on this?
Sure. This builds upon what we were just talking about. So on the academic side, either for ideological reasons or other intellectual commitments, right? We have a constituency that is committed to the view that IP rights are almost always a cost and it's a burden, it's a tax. And like any cost or burden or monopoly rent, we want to minimize that down as low as possible, right? In some cases, eliminate it entirely. And we have a confluence on the other side on industry where with the rise of the digital economy and digital platforms, a business model emerges that monetizes content or tech that is in some cases developed internally, in some cases developed by others, through what I call a giveaway model, what economists call a cross-subsidization model. Okay. So again, we go back to the YouTube example. YouTube takes content developed by others, it gives it away to users. They're not paying anything for it, right? And it's using that to extract revenues from paying advertisers. So in both cases, these two forces converge. One for ideological or intellectual reasons feels that, let's say in this example, copyright should be minimized, should be weakened, should be eliminated in some cases. And on the other side, in the drive for profits, legitimate drive for profits on the side of the platform, they advocate, they lobby, they litigate, right, to expand exemptions from copyright, again, to create very large business circumstances now where you can use content developed by others, often at great cost, for nothing, right? And it's the confluence of these two forces that have reset our IP system in a way that has distorted our innovation ecosystem. It doesn't kill innovation, but it only allows one business model to persist. And over the medium term, over the long term, this is not going to be good for the ecosystem as a whole, because we're going to hurt the small firm innovator. We're going to hurt the individual creator. That won't even be good for the platforms.
Efficient infringement is bad for innovation and for competitors, but it's also bad for shareholders, ultimately. The abundance of new inventions and creative expression and ease of access and copying has devalued many rights in a digital world, especially, and now in the AI world, perhaps even more so. These assets and this content and these inventions feel like they should be there for the taking. You write about the high cost of free, that free or devalued rights undermine competition, and they discourage investment and they prevent healthy disruption, as you mentioned earlier. Can you amplify this?
Sure. Here things may be a little different on the tech and the content side. So let's focus on tech because we've been talking about content. So in tech, there's certain areas that we clearly know with a very high level of confidence that patents are really important. So those would be things like the pharmaceutical industries, chemical industries, portions of IT hardware, portions of semiconductor design. Other industries are less dependent on patents, although they remain dependent on other forms of IP like copyright and contract and controlling access to technology. And that would be much, not all, much of the software industry. Okay? And so what we're seeing, what we have preliminary evidence is that the market is aware that the patent system is becoming weaker. What we see is that VC investment starts to move away from patent dependent sectors and into areas that are less patent dependent. Now, why should we care about that? Well, let's look again at what are those sectors that are patent dependent. That's the life sciences, that's the medical devices, that's portions of semiconductors, portion of hardware. Right. And now moving over to software apps and apps for your phone and so forth. So why should we care about that? Well, there are two reasons. One, we never want in any free market economic system, we want the market to be able to choose freely among different industry sectors rather than that choice being distorted by arbitrary differences in the treatment of property rights. The second reason is precisely those industries that are patent dependent have value beyond economic values. In the life sciences, those are public health values that go beyond pure economics. In hardware and in semiconductor design, those have national security values that, again, go beyond pure economics. So, again, what's the result here? The result here is not necessarily on the tech side a decline in total innovation investment. That's not consistent with what we see in the market, but it's a distortion in innovation flows that is not good as a matter of economics. We don't want innovation choices to be distorted by insecure property rights, but it also has public health and national security implications that could be of incredible importance going forward.
Why aren't more entrepreneurs, creators, investors, policymakers pushing back against the false narratives? The uncertainty of IP, especially patents and copyrights, is the worst enemy of entrepreneurs and investors.
I think there's two things happening here. One is the natural human inclination that we all like to get stuff for a lower price. Everyone likes free stuff, right? But it's kind of like a sugar high for the innovation system, right? We get a lot of free stuff, we get a lot of free content all at once. But over the long term, right, our content pipeline, moving back over to the content side, where property rights are weaker, right, it's going to start to dry up, or you're going to start to have a lot of repetitive content or lower value content. The second reason is that specifically, as I talk about in the book, right around the early 2010s, I talk about two bills that were in Congress. One was in the House, one is in the Senate, the SOPA and the PIPA bills, right? And these were bills that would have expanded the ability of copyright owners to protect their rights in a digital environment. There was a public relations campaign that was led by sites like Wikipedia or companies like Google, and there was tremendous public support and pushback against the bills that were quickly withdrawn. And there was a narrative had emerged that is rooted in the idea IP is monopoly, and therefore everything should be done to reduce it. I think looking back now, especially on the copyright side, where we have the rise of the creator economy, we have individual creators who recognize today the value of property rights. I think we see that was short-sighted. That was prioritizing access over existing content, existing tech at the price, deferred price, so you don't see it immediately, at the price in the future of either less content or less tech.
Tech companies, Jonathan, like the Magnificent Seven, have literally tens of thousands of patents each, yet they don't like strong IP rights. They don't like patents, even though they have them, and lobby vehemently to maintain patent uncertainty and low value. This seems counterintuitive. What's the business logic here?
Let's look at a company that's I don't want to pick a particular company, although we can, a large branded device maker in the smartphone market. What I think is often not appreciated is that the consumer facing brands in the smartphone market, they're generally located roughly in the middle of that smartphone supply chain. What I mean by that is that they are not responsible for the most part in developing the brains behind the smartphone, the computing and communications technologies behind it. Who are those companies? Well, there are literally a handful of companies that are located in the US and Europe who developed the 3G, the 4G LTE, and the 5G technologies that make this amazing device work. Rapid and largely faultless transmission of voice data and other media. What do all those companies have in common? They all have lots of patents, and they monetize those innovations through a licensing structure. Now, who are the licensees? Those are the branded device makers with which the consumers are interfacing. The branded device makers on the smartphone side are just like YouTube on the content side. That patented technology, the brains behind the phone, that's an input. They want that for as little as possible. And so their interests are exactly as you described: litigate, lobby, advocate to weaken the patent system, create uncertainty around patent rights, make it difficult to get injunctions on patent rights, or make it impossible to get injunctions on patent rights. What does that do? Let's take a simple example. Let's just say that it's almost impossible to get an injunction if you have a patent over a computing communications technology in the smartphone system. For the most part, that's actually an accurate statement. Okay, what that means now is that if you're a branded device manufacturer, which are among the largest companies in the world, what is your rational business strategy? I'm going to use that technology and I'm not going to pay you for it. I'm going to invite you to litigate me for years and years in court. And I'm perfectly capable of doing this because I will enjoy profits from your technology. I will be able to fund litigation indefinitely. And the worst case scenario at the end of the day, because there's no injunction, I will be compelled to pay you a reasonable royalty damages that were the same as I would have paid if I had negotiated for you up front. But I'm better off now because I just had the opportunity to potentially push down that rate either through the rate determined by a court or a lower rate that you as the innovator agree to in order to cut off the litigation and save on the litigation costs. So if it's true that IP rights level the playing field, what you do when you weaken IP rights, when you reduce IP rights, now you skew the playing field in favor of the licensee over the licensor. You skew the playing field to benefit some of the largest companies in the world who have not, for the most part, contributed to the development of the technologies that enable devices like the smartphone. And that's why you get this situation that seems quite paradoxical. How could it be that some of the largest tech companies in the world don't like patents? Well, they don't like patents because in many cases they are a net user of technology. They're an integrator, they're an aggregator. They're not the originator of that technology.
One area of the book I thought was particularly important was how you place patent and copyright holders in essentially the same sinking boat. Often inventors and content industry creators do not see the similarities of their condition and avoid working together. But you kind of speak about both being disenfranchised.
Yeah, and that's one of the things I really wanted to bring to people's attention in the book because both in academia and certainly in industry, you're either on the content side or the text side, so you don't see the whole picture. And the picture here, I think, is quite remarkable. Temporally, it occurs roughly around the same time, roughly around the mid 2000s through the present. You have a systematic across the board weakening of both patent copyright in both areas. Why does it happen? It's a confluence of interest between an ideology or other intellectual commitments coming from academia and a business model on the platform side. Why is this happening? Well, one of the things that's interesting about the digital ecosystem, and again, we can appreciate this in our day-to-day life in the smartphone. The smartphone's got content and tech coming together, right? And again, if you are that branded device producer, if you are a search platform, in both cases, you're smack in the middle of the content supply chain. You're smack in the middle on the tech supply chain. What that means is that for the search platform, content is an input. For the branded device producer, smartphone producer, that tech is an input. And in both cases, it's one and the same logic. I want to maximize profits for my shareholders, totally legitimate. How are you going to do that? Get my input costs as low as possible. How am I going to do that? I'm going to both bargain with the content suppliers and the tech suppliers, but I'm going to do something else here. And that's the key insight of the book. I'm going to change the rules of the game. I'm going to take that content, I'm going to take that tech, I'm going to induce a litigation, and hopefully I'm going to secure precedents that weaken the property rights. And from that point forward, all of the bargaining leverage will be in the hands of the content user. the tech user, that's the platform. That's what this book is about, a wealth shift. It's about shifting wealth from the innovators in the US innovation ecosystem to the aggregators and the intermediaries. And what I try to argue in the book is this has things completely backwards, right? Over the medium to long term, we need to incentivize the innovator. The aggregators will be okay. They will take those innovations on the content and tech side, they will integrate it in a way that delivers value for consumers. This book, as I said in the beginning of our conversation, is just about common sense. It's just about saying we need to restore property rights infrastructure so that if you develop content, if you develop high value content, you develop high value tech, you're paid for it. It's as simple as that.
I'd be remiss if I don't mention that upcoming is the 2025 IP Awareness Summit at Dolby Labs in San Francisco, April 24th. And you'll be speaking and moderating a panel called AI's Emerging Role in Innovation, Creative Expression, and IP Rights. Can you give listeners a taste of what you would like to discuss and AI's role in all of this? Will AI improve the situation? Is it heightening the importance of content, for example, or is it just going to continue to get worse?
Yeah, so the book came out fortuitously right when we have a new digital paradigm shift going on here, and that's the AI transformation. And what we're seeing actually is interesting, something different than occurred back in the dot-com area or back in YouTube. We do not see the AI model and app developers entirely ignoring copyright. We see licensing deals taking place. We see licensing models being developed, even though it's emergent. Why is this happening? I think there's two reasons. One is, as I mentioned previously, we have the rise in the past 5 to 10 years, roughly, of the creator economy. So now we have a constituency of individual creators who have a vested interest in their property rights being recognized. Their business model is not a giveaway business model. It's a traditional business model, and they require property rights. The other thing that happened is that in 2023, in the Warhol estate decision by the US Supreme Court, the court essentially pushed back against the consensus trajectory in the lower federal courts that had continuously expanded the fair use exemption. And to simplify the opinion, the court in the Warhol decision said, lower courts, you're going so far that fair use is in danger of swallowing up all of copyright, right? And that case was a classic individual creator case. It's an individual photographer seeking a licensing fee from the Warhol estate. That's it. Not trying to shut off access. Again, just she was seeking to be paid for her content. And because of that decision and some other decisions in the Second Circuit and other appellate courts that have pushed back against fair use, we see the pendulum shifting slightly back on the legal side. It's created enough uncertainty, enough legal exposure for the model and the app developers. We do see some licensing activity taking place, not as much as I think we would like to see. But it is an interesting interaction there where you see how the change in the property rights system impacts the willingness of content users to start at least talking to content developers.
Is there anything we can do, Jonathan, to educate and inform audiences, inventors, creators, entrepreneurs, investors, policymakers, the importance of IP rights and the danger of weakening them? What devices, other than your book, of course, can we use to put things in context?
Sure. It's important to get the message out there, both to policymakers on the legislative and the regulatory side. I think it's important to educate the judiciary, who have in their power the ability to issue remedies such as injunctions, which is the most powerful remedy that could re-level the playing field. in the IP marketplace. And there's two key messages I think that it would be helpful to convey to those in the ability to impact policy. One is to reaffirm an awareness that tech markets and content markets are really not so different at the end of the day from just your regular old physical goods markets. People need to get paid. Investments have to be elicited. These require property rights, right? And that logic is familiar. It's not controversial in the physical goods area. And with some adjustments for intangible goods, that logic largely prevails in the intangible goods area, whether you're in content or tech. The second is more a job for academics. There is evidence that shows, especially on the tech side, that secure property rights are necessary to support investment in innovation areas. The evidence is especially strong in pharmaceuticals, which, as I mentioned previously, raise not only economic concerns, they raise public health concerns. So I think a fair-minded view, a balanced view of the evidence would go a long way towards enabling policymakers to reappreciate the importance of property rights for our innovation system.
We're running low on time. What has to happen to get the IP rights system back on track? China is closing in with their own robust IP system, which has injunctions and competitive technology like DeepSeek, et cetera, products and services. They're sort of using structure of our system in ways that we don't any longer. What has to happen to get us back on track?
Yeah, so two things on that. One, we as a free market economy and as a liberal democracy have a great advantage over any authoritarian system because innovation thrives under freedom of enterprise, freedom of thought, freedom of inquiry. And how does IP rights fit in this system? IP rights are often misconstrued as simply a tool to block access, to impose a tax. In fact, absolutely. And even more than that, right? Even more than that, IP rights enable markets to form. They enable investors to invest money in a biotech startup, to invest money in a new content production company. So it supports that bottom up process of allocating resources that is always going to outperform a command and control economy over the medium to long term. To enable that, what I call enabling function, that market making function of IP rights to work, IP rights really have to function as a property right in a meaningful way. And without getting into all of the weeds and the details of the various twists and turns in which our IP system has been weakened over roughly the past 2 decades, I'll just focus on one, which is in the patent system in particular. For very large categories of patent owners today, an injunction is almost impossible to secure. Once you do that, you have unleveled the playing field by favoring the largest firms who can simply take the tech that they want and induce a litigation. The litigation is either impossible for the small firm innovator to fund, or they will be forced to settle at a price that does not reflect the value of that technology. When you do that, patents start to lose their property-like function, and they no longer are able to support markets. Innovation then is driven into the largest companies instead of taking place among the small firm innovators. And I think that may have been what you were referring to when you call an IP right. It's not a monopoly right, it's an anti-monopoly right. That's exactly right. It levels the playing field by enabling the idea factories to function, to secure investment. This challenges the platform, it challenges the incumbent, and makes the innovation ecosystem as robust as it can be over the long term. And that's the true advantage of a free market system over a command and control economy.
Wow, that's great. Thank you so much, Jonathan. This was really incredible discussion and a very timely one. Once again, audience, I just want listeners, I want you to recall that Jonathan will be in San Francisco at Dolby Labs, open to the public on April 24th. It's the IP Awareness Summit. He'll be on the first panel, and he'll be available somewhat throughout the day. There'll be breakout sessions, et cetera. You'll be joined by Jerry Ma, Chief IP Officer of the USPTO, among others. So it's an interesting group. Tickets are still available. Space is limited. Thank you, Jonathan. Safe travels, and we'll see you in a few weeks in San Francisco.
Looking forward. Thanks for being here today.
Understanding IP Matters is brought to you by the nonprofit Center for Intellectual Property Understanding with the generous support of its partners and sponsors. Gain access to all 4 seasons by subscribing for free on your favorite platform or email us at explore.understandingip.org. Content conveyed is for informational purposes only and does not represent the views of CIPU or its affiliates. This episode was produced by Jack Shields for Wild Creek Studios. Thank you for listening.